Welcome to the Federal Retirement Podcast. My name is David Rates from Benchmark Financial Group, and every month we discuss important topics regarding the retirement planning process for federal employees. This Lunch and Learn series is an interactive discussion where individuals can ask questions. To join these discussions live, you may register by joining our email list at bfgkc.com. We also provide in-person retirement planning and benefit education to federal employees. To learn more about these seminars or to schedule a seminar at your federal agency, go to our website at bfgkc.com and click on seminars. Additionally, if you're looking for assistance to get your retirement on the right track, set up an appointment with us today. You can schedule an appointment online by visiting our website at bfgkc.com or email me at david.rates@bfgkc.com. The contact information is also listed in the description. By setting up a complimentary consultation, we can review your financial situation and develop a plan to meet your financial goals. We hope you enjoyed this topic and hope to connect with you soon.
Having a valid will is essential for ensuring that your assets are distributed according to your wishes when you die, after you die. Despite this, it is estimated that only 44% of Americans over the age of 55 have wills, and only 22% of those younger than 55 have a will. That means a significant portion of the population is at risk of dying intestate or without a will, leading to possible complications for your loved ones. Today, we are here to discuss the issues with our attorney in our office, Linda Marshall, who is introduced by David Rates, president of Benchmark Financial Group. David?
Well, thanks for tuning into this month's call, everyone. Like Patty was saying a second ago, Linda's been operating her law practice in our firm for quite some time now. And thanks again for being here, Linda. Brings a unique point of view to estate planning. So, all righty, getting started. So dying intestate, in your words, Linda, what would you say dying intestate means?
That means you die without a valid will. Testate is, if you die testate, that means you have a will, and intestate means you don't have a will.
Okay. So when we're talking about the main bullet points of dying intestate, what are some of the, if you have a living will, what are some of the assets that are not affected by intestate succession laws? Like you hear a lot of chatter about beneficiary designations, wills, trusts. So I guess what are your thoughts on that, Linda?
Well, first of all, there's a difference between a living will and a will.
Okay.
A living will refers to your advance directive for healthcare.
Okay.
And so that is something that applies during your lifetime. A will only becomes effective on death, and it's what your instructions are for how your assets are to be distributed and when. Basically, it's your speaking to the issues regarding your estate, your assets. You did mention some things are not covered under a will, and that is anything that has a beneficiary designation. So if you have a life insurance policy, you designate who the beneficiary is to be. If it's an individual, then it's immediately distributed to that individual. The same way with your pension plans, IRA, 401k, etc. You designate on that who your beneficiary is that you want to get to receive those funds upon your death. Those things don't pass under your will. They immediately pass. And of course, anything that's owned jointly, like your house, you may own it with your spouse and have it jointly titled. That would pass immediately just to your spouse. And some things also have a transfer on death provision, maybe a bank account or your vehicle. If you own your vehicle individually, just in your name, you can have a provision on it that says transfer on death to, and then it passes automatically to that person on death. It's not considered part of your estate and not controlled by what you said in your will.
So is it relatively easy to add a transfer on death provision to real like a house or a car? What I guess 1,000 foot out view, what does that process entail? Just a matter of deciding, how you want things to pass and filing the appropriate paperwork.
Yes, a beneficiary deed says, I own this property, and if I still own it at the time of my death, I want it to go to this beneficiary, the people that are named. I've done any number of those. You prepare the thing, it's signed just like a regular deed when you buy a house,
Yeah.
and then it is filed with the court.
Okay.
Well, not the court, with
Yeah.
the recorder of deeds, register of deeds in Kansas. And as long as that person, the beneficiary named, is still living, and as long as you still own the property at the time of your death, it goes to them immediately. It doesn't affect at all your ability to sell the house, to transfer it to somebody else, whatever. It's
Yeah.
only becomes effective at the time of death.
And I'm guessing if you wanted to change that, that's just a matter of resubmitting the appropriate paperwork with
Preparing another
yeah.
deed, and filing it.
All right. So in a general sense, how is a will valid in the eyes of the legal world? I mean, what are some of the main pieces that take place? Because I'm guessing there's a difference between like the legalzoom.com version and the version that might be drawn up the way that you want it to be drawn up.
Yes, and especially I've seen lately ads for, like, what is it, $50 or $100
Yeah.
to do your will online or something, and I haven't looked at those documents. I don't know how they're set up or how they're done, but my concern is that it might be worse than not having one, because if you do something like that and you rely on, you think, hey, I've got everything taken care of, and then it isn't right, you've relied on it, and it's not only your detriment, but the detriment of your family.
Well, and I've participated numerous times, and you normally have at least 2 witnesses for everything you do. All of the sensitive pieces of information have to be notarized, and I mean, if you're doing that with a click of a button on a website,
Right.
A, it might not pan out the way that you want it to, and B, it probably would be easy to contest in the event that somebody wanted to contest it.
Even when I've done a will for someone out of the area here, I want to be present electronically when they sign everything, so that I can make sure that everything is being handled properly, that everyone is present at the same time, and that they certify what they need to certify. So the requirements for a valid will, first of all, it should be in writing.
Yeah.
There are a few very unique exceptions, but it should be a written document. Then obviously signed by you, the testator.
Like a ink signature type of document, yes. Old school
ink signature,
paper document.
Absolutely. And each page should be initialed. Even the page that you sign should be initialed. Then you have 2 witnesses who are present at the same time as you're signing. Everybody's present together. Everybody certifies that they're in the presence of each other and watching the proceedings. And the 2 witnesses both initial every page. Then on the final page, the testator will sign full name, again, initial, the witnesses initial, the witnesses sign also. And then there's a final page, which is a notary, a notarization certification that everything was done properly, everybody signed in everybody else's presence. That page is signed by everybody, and the notary certifies it. So, and the notary, of course, has to be a notary in the state in which it's signed. So those are the technical requirements. Those are, there's certain things that are supposed to be said as well, and those are included in the document. But basically, you have to, the testator has to say that this is in fact, declared to be his or her last will and testament, and that he or she is over 18, because you can't do a will unless you're over 18. And then that they're not under any compulsion or coercion, and doing it of their own free will, and asking the witnesses to witness their signature, to witness the testator's signature, and then you proceed with the signing.
So what are some of the situations that you've seen, God forbid if somebody passes away without a valid will, do they have control over the process? How does probate, sift through all of that? Does it take extra time and money?
Yes, it does, absolutely. And not everybody does. As you started off by saying, something like 64%, it's estimated, of Americans over the age of 55 don't have a will. And, I mean, if you look at people under that.
It's kind of a strike. I can understand people like 25.
Yeah, yeah, but even under the age of 45, it's estimated that 70% don't.
Wow.
And so, yes, it's amazing. There are famous rich people who've died that have been in the news not too long ago, who didn't have a will. Prince didn't have a will. I mean, he had,
which, like, he's got his whole portfolio of music, which is still generating revenue to an estate that somebody's going to be beneficial. Yeah.
Martin Luther King Jr. didn't have a will. I mean, and he was somebody who knew that he had death threats, but he didn't have a will. Jimi Hendrix, I mean, he should have known he was at risk because of all the lifestyle choices he made, right?
Yeah.
Then Howard Hughes. I mean,
I was going to say that was one I was kind of thinking of too.
He was ancient and very wealthy.
Yeah, very wealthy.
And then Michael Jackson, when he died, it was believed that he didn't have a will. His family contacted and told the court he didn't have a will, and then later a will was found, which is another issue. Even if you do have a will, make sure somebody knows where it is, and can access it. So if you've put it in a safe deposit box somewhere,
and
make sure somebody knows. Although I would think that the bank with Michael Jackson would have notified family.
Right.
I mean, they would know that he died.
Yeah.
But anyway, kind of a side thing there about that. So that now I've forgotten what your question was.
So with a will, can you determine a specific person to help you? I mean, obviously you passed away, but do you have the power to determine entity or a person that can help your family or your loved ones settle your estate in the way that you want it to? Or
absolutely,
does that require additional levels of legacy planning?
That's one of the main benefits to a will, is that you determine who handles your assets after you've passed. You name an executor, or it's now referred to as a personal representative. You name who's going to be in charge of handling everything and making sure that property is distributed the way you want it to be, and how it's to be done. You can provide that your personal representative is not to have to pay a bond. And a lot of things like that you in your will can control and make easier for whoever you've named. And also you then have control over who gets what when.
Yeah, especially I would imagine when minor children are involved. Not only is it a question of who's going to help those kids from the point you pass away until the point that they're legal adults, but usually, at least in our world, the running joke is if you got 2 or 3 kids, sometimes people aren't concerned about 1 or 2 of them, and then they're concerned one of them might go buy a new brand new Maserati if they get like a couple $100,000 at a certain point in their lives. So.
Exactly. You can set it up so that so that it's only distributed at certain ages and in certain amounts. And that would be by a testamentary trust, a trust created within the will, not a separate trust, that a living trust, that a fiduciary trust. So you control both the process, how much goes to your loved ones, and when, and also who's going to have the guardianship of your
Yeah,
children.
because guardianship is one thing, but then you have to determine, what's the entity that's actually going to manage this chunk of money
Right.
with, in conjunction with the guardian.
And it doesn't always have to be the same person. You may want one person to be the guardian of the person of your children themselves,
Yeah.
and somebody else to manage the money.
Yeah, that's
Because
just because a caregiver might not necessarily be the most skilled person with financial decisions, obviously. So
exactly. And this way, when you have a will, you can have control over that part of it as well as the financial process. So another benefit of a will is that if you don't have a will, it's probably going to be a slower process in getting everything resolved, and also cost more.
So in a general sense, how does the probate process work? So probate court eventually sees that your wishes are carried out, but do they do that at lightning speed, or?
I would have to
What's your
say not
experience?
necessarily. Some courts move faster than others. Some judges move faster than others.
Yeah.
But there are some things that have to be kind of slow, because there's a notice that has to go out when a will needs to be filed with the probate court of the county in which the decedent lived. That gives notice to everybody that the person really has passed. And also it starts running a time frame during which any claims can be submitted.
Yeah, we just had a client that it was like a 1 or 2 year process of you have to put an ad in the newspaper, wait, X amount of time for creditors to file a claim before you can move to the next step of settling.
But if you don't file that notice, don't file the original will, the time doesn't start running. And so you don't want that. You don't want to have a creditor come up way down the road and say, hey, you didn't give us notice. So when someone passes who has a will, it should be filed in the probate court. And then after that, sometimes it's not necessary to start a probate proceeding, but usually it is. If there are no assets, there's why bother? But if there are assets, it should be filed, and then the court will make sure that the will's provisions are followed.
So are there situations where the court has determined a will not to be valid? Like, I guess when you say that the court determines the will to be valid, what would be a scenario when they kick a will out?
Well, if all of the requirements for signing haven't been met, and it used to be years and years ago that you didn't have the notary form on the back of a will,
which
and so you had to track down the witnesses,
and if they're not around,
who swore that everything was done properly. If they weren't around, it was a slower process.
Yeah.
I mean, when I first started in practice, I was a witness on a will, and a few years ago, I got an affidavit I had to fill out, but everything was done properly. And I'm going, I don't really remember, but I trust the person who was in charge, and
It really makes you think, like, if you extrapolate this out years, the legaldocuments.com, that's kind of you could argue, relatively new thing. So it'll be interesting to see if people don't necessarily dot the I's and cross the T's in the right spot and assume everything is right. What's going to happen to those legal documents when you if you print it off, file it in a file for 30 years, and then God forbid you pass away and you think you're good to go.
Exactly. So those are things the court checks to make sure that all of the rules have been followed. Another thing the court checks is to make sure that family members are considered. So if you have 2 kids and you know, you got divorced when, long time ago, and the kids have not been in contact with you in decades, and never wanted to see you,
Yeah.
rejected any attempts, and you say, why should I remember them now when they never remembered me in my life? Well, if it's not addressed,
Yeah.
it can be a problem, because the court can say, well, he maybe forgot that he had these kids.
In a legal sense, they're the next of kin in
Yeah,
certain
they are.
situations.
They
So,
are. And so I was involved in a case like that. And we ended up settling, the kids got something, even though the
Yeah.
father did not want them to. But he wanted to leave everything to charity. And
So it seems like, in a lot of situations, if you do your due diligence on the front end, you can sidestep this long drawn out probate process, which oftentimes, ideally it would put you in the same spot as you were planning to be if you had you done that planning on the front end. It just takes years
right.
or God
And
knows how much extra time and money.
And money.
Yeah.
Mhm. Because when everything isn't done according to Hoyle, then it does take more time and it does cost more, because like the situation with a man whose children had basically abandoned him.
Yeah.
Um, the kids had a lawyer. There was a lawyer for the charity, I mean,
Yeah.
and this is paid from the estate. So, and the charity he wanted to give money to didn't get as much as he wanted them to.
Are there situations where the formal probate process, I mean, I get to your point, determines things based off of the systems that are in place for them that might not necessarily jive with the way that you want to have assets inherited, like asset distribution priority in Kansas and Missouri, for instance?
Oh, yeah, absolutely. If you don't have a will that you've prepared yourself, the legislature of the state has prepared something that they thought would probably can be what most people would want.
Yeah.
Yeah. And as we know, what the state law is maybe not what your situation is. If you have a spouse, everything that you have, a spouse and no children,
Yeah.
everything passes to the spouse. If you have a spouse and children, the spouse only gets 50%.
Which I thought that was really, interesting, because your mind would kind of auto default to like when the court look at the surviving spouse as the person in priority in terms of like maintaining their cost of living, as opposed to an auto 50% to the surviving spouse, 50% of the kids.
Right. And
because let's say that spouse is in their mid 80s and
even if
they need certain assets to maintain
even if they're just 67, just retired, they may not be able to live on half.
Yeah.
Now, if the house is jointly titled, the spouse will get the house, but the spouse may not have enough money.
Especially with like pension benefits and things like that. If if while you're both alive and well, the auto default for a surviving spouse benefit is half your pension.
Right.
It could be a situation where they're living on half.
Exactly. Well, no, the pension amount is going to all go to the designated beneficiary, the spouse. But still, half of your pension, it may not be enough to certainly maintain your lifestyle.
Yeah.
So, and if you are married with children, your spouse had children from a prior marriage.
Yeah, I was just thinking about that. What like stepchildren are they looked at?
It's the same.
Yeah.
If they're children of the person who died,
yeah,
they, among all the children that person had, they get 50% of the estate. So
the cookie cutter option could
be
easily pan out to be a situation where it doesn't necessarily take the path that you ideally wanted it to, and
Right.
It seems like a lot of oftentimes we'll all be dead. They can figure it out. But even if you're, kind of looking at it, the world through that lens, you still have opinions on who, most of the time, you still have opinions on, who would get what and how they would get it. So
if the person who died was not married at the time of death, then the children get everything. And it's divided among them equally, regardless of what marriage it was that they were born from. And if there are no children and no lineal descendants, so, you may have grandchildren who are living but no children, that would pass on to the grandchildren equally through the child or children who died. So in other words, if you had two children, both of whom predeceased you,
yeah,
their children would step into the shoes of their parent and get half, 50%.
Yeah.
But even, and that's true even if one child had only had one child, one grandchild by that, and the other one had 10,
yeah,
the one grandchild from the one would get 50% of it, and the others would.
So that's like a per stirpes situation. Because even in our world, you have to, like when you're opening up an investment account and you check the box for per stirpes, you have to name a designated person to be point of contact, just for like the investment account itself, not taking into account like a whole nother echelon of estate planning.
Yeah.
So
So
Linda, do you see situations where you have children and one child is pretty close to finished with their education, the other one still has 8 to 10 years before did they adjust the beneficiary to accommodate that so that both kids had at least had a shot at the same educational opportunities?
a will does not do that.
It's got to be.
The will is just numerical.
It has to be accounted for though, and that's the whole point of.
Right. Where that's the situation where a living trust is really good, because a will only comes into effect at death. A trust comes into effect as soon as it's signed. And with a trust, you can be specific and say, one child is out of school and not working, one child is not, and we want that child to have their education and maintenance support paid for during that time. And in fact, you can say until something, whatever you want to give. I often recommend in a trust that the distribution be piecemealed out, so that say the person died at 18, when one child was 18. If they just have a will, the child is going to get their inheritance at 18. They're considered an adult, so they don't have to have a guardian, so they get it at 18. At 18, the child may think they need a Maserati instead of a Ford Focus to go to school.
Or longevity of money.
Yeah, exactly. Whereas in a trust, you can say, I want things distributed, say, the trustee is to give them money to pay for education, maintenance, support, but they're not to distribute assets until they're 25, 30, and you can space it out. So say a third at 25, a third at 30, a third at 35, to give them, I like to think of it as the first distribution being kind of like training wheels. So if they blow it, then they've still got whatever you've left for later distribution. Also, people are often concerned that if there's an early marriage that is not something that's long lasting, they don't want that new spouse to then on divorce get some of that money. And they won't, as long as the person who inherited didn't put it in a joint, a joint asset. So if they buy a house and title it jointly, then it's half and half.
You might want that portion of the estate to go to their children and not necessarily the spouse
Yes.
have like an auto
Yeah.
entitlement to that chunk of money.
Also, if this isn't the first marriage for the couple where the one died,
Yeah.
you may not want to leave everything to the surviving spouse, because the surviving spouse may not be so concerned about his children as they are about their children from a prior marriage.
Yeah.
And so those are all things that make it really good to consider a trust in addition to a will. They don't, a trust doesn't replace a will, but it's in addition.
But it seems like the process of going through drafting a trust forces you to address these decisions that somebody needs to make. And ideally, you probably want to be the one making those decisions, because if you take that, well, I'll be dead and they can all figure it out, somebody's going to have to make certain decisions and do certain things to settle your affairs.
Right.
And then it's a question of, do you want to dump this into somebody's lap at the point that you're not here anymore? Or do you want to have some say in what happens while you're alive and well and can make that decision?
Well, and not only,
because I feel like in our world, oftentimes the auto default is that like estate planning is for the ultra high net worth person out there, and most people don't necessarily need it. But I mean, even if you're not necessarily dealing with a estate that's in the hundreds of millions of dollars, there's going to be decisions that need to be made. And
that's right. And not only does it maintain control for you on how you want things done, but it also leaves things much neater for your loved ones, because you've set out how you want things handled. You've named who you want to handle it. You can name, a successor personal representative. I don't know how many people I've had come in and say, well, we have 3 kids. One of them definitely cannot handle the paperwork and such. This one can,
yep.
And so I think this one would be best, and this one would be second.
Yep.
We can name the other one third, but so that he or she doesn't feel left out. But you can make those decisions, and it's so much better. If you don't have a will, the court appoints an official with the government to act, and they charge. They're entitled to money, but
it's a macro thing. Like they have to have a program that's a one size fits most, general guide type of situation. So,
and it also, I think the biggest benefit that I see is that it gives peace of mind to your family, that you've thought about this, you've said how you want things handled. They don't have to fight over it.
Yeah.
And it's less stress for them, as well as less
and
mess.
You certainly see it, at least on our end of the spectrum, when somebody's actually had to go through be the point person of settling the estate of a loved one that passed. It changes your view of the whole process.
Yeah, absolutely.
Kind of opens your eyes. Maybe it's not specifically reserved for the ultra high net worth person out there. And
that's right.
Maybe it does make sense for everyone to have some guide on how they want things settled, and have some discussions about who they want to help them administer that.
I've always thought that you spend all your time and effort to create an estate. And what we're talking about is the amount of money that's you've been able to accumulate and grow to a certain point, but you sacrificed, and that's the key word, to get there. And so why would you just ignore that part of it when it was so important to you to develop or to create it, because of the way the life is, that now that you're not in the picture, it should just evaporate?
Right.
I would think just the opposite, that you'd want to have your hands in it and say, this is what I would like to.
Absolutely. And not just the money end of it, but also their family things.
Right.
There may be grandpa's watch that you want to go to one particular child, and who's interested. And it was close to grandpa.
Yeah.
You know,
And there's sentimental value tied to it.
and there's jewelry.
Yeah.
Some people have multiple rings that are of different value,
Mhm.
and yet, you know, you want this one to go to this daughter and this one to go to that daughter, and then they don't have to fight over it.
Yeah.
And some of those
So you
fights,
don't,
you know,
I was gonna say money sometimes in those situations is thicker than blood. And it's like, well, dad said the watch was mine.
yeah,
So
exactly.
I got here first and I took it.
Yeah, exactly. And you know, there are horror stories about people fighting over a chair,
Yeah.
you know, and things that are really of very little value, but
Yeah.
it creates stress and strife in the
Major
relationship.
divide.
And some of those are never healed.
Yeah, and it's already stressful enough. Why do you know, why do you need to potentially have extra variables over something that's not necessarily worth, like monetary wise, a ton, but could potentially drive a wedge between siblings or family members when you don't necessarily need that to take place. So
Right. So not only is it something that is financially good and time consuming good, but also it's a legacy and a real sign of your care for your family. I think if you prepare for the eventual passing, we know that it'll happen sometime, and most people, after they've done an estate plan and are walking out of the office here, say, I feel such a relief.
yeah.
So
Because even if you bury your head in the sand, somebody's going to have to either court appointed or a loved one that decides to, you know, carry that torch. Somebody's going to have to deal with settling certain affairs of yours. So, Patty, any questions from the group?
No, there are no questions right now. David and Linda, do you have anything else?
Thanks for tuning in, everybody. If you'd like to reach out to Linda, you can always give her a call or send her an email. And like I said, thanks for tuning in, and we'll hope to see you guys at some point in the near future.